I want to give a shout out to @handle-numbers who asked, how does one go about learning about the employer's insurance policy? Good question, and a fair one. After all, litigants sue for damages that often involve money. And courts realize that, and they expect companies to be insured, and they expect companies, when they're being sued, to disclose the insurance company that covers them in the event they are sued. And not only that, the defendant's attorney or attorneys also have an obligation to disclose the insurance company and the policy amount. @handle-numbers also ask, at what point does one ask or request this information, and how can one try to press the matter if they meet resistance? Another good question. And these are the things we're going to discuss in this video. So let's get started. So let's deal with the first question. At what point does one request this information? During the initial disclosures. Now, this is a critical stage of litigation, and a lot of litigants miss this. Prior to the time formal discovery begins, the defendant is required to produce certain documents even without the plaintiff having to ask for those documents. This is the initial disclosures. And included in these disclosures would be the defendant's insurance information. Federal Rules of Civil Procedure 26, small letter A, 1, capital letter A, and Roman numeral 4 states, a party must, without awaiting a discovery request, provide to the other parties for inspection and copying as under Rule 34 any insurance agreement under which an insurance business may be liable to satisfy all or part of a possible judgment in the action or to indemnify or reimburse for payments made to satisfy the judgment. And let me reiterate that the employer defendant and their attorney or attorneys have a duty to inquire about and investigate the employer's insurance coverage. Failure to do so could result in them being sanctioned. For example, in Palacino et al. Versus Beach Mountain Resort, Inc., a 2015 case that was filed in the Western District Court of North Carolina, the attorney representing the defendant failed to disclose the extent of the insurance her client had for a claim. The court found that she failed to properly discuss and review the $1 million insurance policy. The court also found that further inquiry would have revealed a $10 million umbrella policy above the first $1 million policy. The court sanctioned the attorney and the defendant $1,500 respectively. The second method is formal discovery. And of course, the ones we most often use are admissions, interrogatories, and production of documents. And of course, there's depositions. So let's answer the second question. How can one try to press the matter if they meet resistance? Now remember this. Under Federal Rules of Civil Procedure 26, a party must make the initial disclosures at or within 14 days after the parties' Rule 26F conference, unless a different time is set by stipulation or court. So, plaintiff, if you have not received the disclosures by the deadline date, you want to immediately begin to engage in a good faith effort to resolve your dispute because you guys have a dispute right now. And what does that effort look like? Generally, jurisdictions require that the parties show that they've made a good faith effort to resolve the dispute. And one of the ways we do that is in the good faith letter. You can Google for a sample good faith letter. And if the good faith letter does not produce the documents or information, and you believe that the party is wrongfully withholding documents and information, you have an option to file a motion to compel and ask for sanctions pursuant to Federal Rules of Civil Procedure 37. And by the way, the same rule addresses the good faith letter. It's important that you show that you've made a good faith effort, okay? Here is a takeaway I want you to get from this. Don't wait until formal discovery begins to get the insurance information. That information is required to be disclosed at the front of the lawsuit during the initial disclosures because you want to get your hands on that insurance information as soon as possible because you may have to conduct some investigating yourself or even hire someone to assist you in investigating this insurance, okay? So don't be shy and don't be timid. If you have to file a motion to compel, then you have the right to do that, okay? Be proactive, be empowered. I'm Advocate Lucinda, and we will see you next time. Take care.